Let's fire those sirens up, guys. Well, it's breaking news. YouTuber Delete Laws has won his appeal. He was released from jail today. Here is a complete rundown on his court cases as it happened. Y'all have a good one. Make sure you like, comment, subscribe, and share. He's going to get paid for this. He's going to end up suing. So, y'all check it out.
Castro, can you turn off your phone, please? The one that's in your hand.
Just communicating with my lawyer. He's on his way here now. So I'm just waiting for him to get there.
Alright, I'm gonna wait for your attorney, okay?
Okay.
Thank you.
Thank you.
Alright, Jose Castro, 23 Sierra 013015.
Good morning, Your Honor. Agnes Botello, and Ms. Kate for the record. Good morning, State.
Good morning, Mike. Can you on behalf of the defendant, President this morning?
So I had signed 2 media requests that permit recording or photographing these proceedings, but I have not granted any other requests to record or live stream these proceedings. So I need Mr. DeCastro and everybody else who wants to stay in the courtroom to surrender their phones, or you can leave.
Are your phone numbers not take one for you?
I need Mr. DeCastro to empty all of his pockets.
What's that? Yeah, empty your pockets and give up your phones to the judge. I have to give you my phones?
Yeah.
My phones have to be completely off.
Yep. I don't really want to be part of your YouTube channel. So,
You already are.
great.
You already are.
Awesome.
I'm not gonna get into this guy though. I'll get into someone else. I'm
No,
not touching this.
no, they're gonna go to my marshal.
He's a pig.
Excuse me?
I said he's a pig.
Okay. So I'm not gonna permit you to speak to anybody in my courtroom in that manner, and if you don't wanna apologize, I'm gonna hold you in contempt.
I apologize to the court, Your Honor.
No, you can apologize to, they've done nothing to you.
Actually, Your Honor, when you were here, you came over and gave me a directive for no reason and started telling me what to do.
Okay, well,
I have all the respect in the world for the court. I follow the rule of law all the time.
no, it is their job to maintain the safety and security of the courtroom.
I agree with you, Your Honor.
So, if you want to speak like that in my courtroom, I'm going to hold you in contempt. And if I hold you in contempt, you're going to jail. That is not my wish. Okay?
I wish you would.
All right. So, I need you to empty your pockets too. Suit pocket, pants pocket.
This is illegal. This is a violation of my Fourth Amendment.
No, it isn't.
Yes, it is. I don't have any recording devices on me. What are you talking about?
Right. Suit jacket.
I don't have anything on me. This is preposterous.
No, it's
This
not.
really is.
No, it's not.
Yes, it is.
Mr. Me, your phone too.
They're recording everything.
They have a media request.
Right, and I'm not recording anything. Is it your guy here took my phone, so he's not, his phone's not on.
Right.
You take the lawyer's phone too?
No, I'm not going to take the lawyer's phone. He's an officer of the court. All right. Do we have everybody's phones? Are they off? All right. Good. All right. All right. This is the time set for the trial of State of Nevada versus Jose Castro, 23 CR 013015. The state ready to proceed.
Yes, we are, Your Honor.
How many witnesses do you have?
Mrs. Kate 1.
All right. Is the defense ready to proceed?
Yes, Your Honor.
All right. I have your request to convert counsel to standby counsel. I'm going to deny that request. Either you represent him or he should have previously requested a Beretta canvas to represent himself. That I just consider that as a late tactic, so that request is denied. Are you ready to proceed? Otherwise, I'm assuming you are.
Yes, Your Honor.
All right. Will the state please call the first witness?
Yes, Your Honor. The state calls Brandon Ford.
law in that area, Your Honor, is that if it's an unlawful arrest, which it was in this case because they're essentially arresting him for violating these unlawful orders that they're pronouncing. Again, the case law is you can passively resist an unlawful arrest, and that's all that occurred here, Your Honor. Thank you.
All right, Mr. Castro, please stand. The problem with the argument that your attorney makes is it completely fails to consider the safety of the officer and the safety of the driver. The officer doesn't know who you are, and the driver doesn't know who you are. And you don't have any right to interfere with that officer doing his investigation and deciding if he wants to issue a ticket to this driver. And you also don't have any business approaching the driver. The driver didn't ask you for help. The driver didn't say, help, help, you know. You didn't see an altercation happening between the officer and this driver. The officer didn't protest that you were filming. There's no problem with filming. You can film, it's fine, all right? But you did interfere with his investigation. You did interfere with his ability to do his job. You did put him in a position where he is concerned for his safety and the safety of the driver. So I believe the state's met their burden beyond reasonable doubt. I'm going to find you guilty of obstructing a public officer and resisting a public officer. So I'd like to hear from the state and then your attorney prior to sentencing.
Your Honor, in terms of sentencing, I would ask the defendant enter and complete an impulse control class. I would ask that the court levy a $500 fine or equivalent in community service. I would ask that the defendant be ordered to stay out of trouble for the pendency of the case. And I would ask for a 90-day suspended sentence. And that's on as to each count to remain current. That's our request. Thank you.
Your Honor, I'm asking the court to sentence the defendant to credit for time served for these offenses. Even if the court concludes, and the court did conclude that he didn't have the right to do what he did, I think the court can see that he sincerely believes that he had the right to do so. That's based on his past experiences and the training he's received in reference to the First Amendment. I don't think there was any intent from the defendant to engage in any wrongdoing in this case, Your Honor. And that being the case, especially because of the public policy interests at issue.
So when you say he doesn't wish to engage in any wrongdoing, it seems to me from observing him in the video that he wants this. He wants to get arrested. He wants to get into an altercation with police officers. He welcomes this. This helps his YouTube channel. He called the officers here in my courtroom today pigs. He called me, and he's nodding his head up and down. So apparently he hates every law enforcement officer in the United States. All right, please stand up, sir. Are you finished with your request for credit for time served?
I would just emphasize, Your Honor, that the defendant testified and he sincerely believes that he is providing a public service when he reviews and films these incidents. I understand the court may have a different view of that, but when we're talking about First Amendment public policy issues such as supervising people involved in government, I think that is something the court can take into consideration, not to have a chilling effect on that. I'll sit on it, Your Honor.
And Mr. Castro, please stand. I hereby sentence you to 90 days in the Clark County Detention Center on count 1, 90 days in the Clark County Detention Center on count 2, to run consecutive for a total of 180 days in custody. Thank you.
Sentence suspended or?
Oh no, I'm going to start right now.
This is Castro Justice.
Federal case law suggesting you can hold police officers, but the state this case, you have a person who, for a living, this man for a living, that's his living, he films police officers. He has more than 500,000 subscribers. He is very, very famous as a First Amendment auditor. He is known as he testified around the United States and does this constantly. I look at this case, there are multiple problems with it. It goes to trial, so let's start with what really happens. There's a letter written to the judge, and if I cite to it, and you have a copy in the appendix. And the letter says this man's going to film the proceedings. The judge says, empty your pockets, suit pockets, all sorts of pockets, empty them. He says why, he complains it's a Fourth Amendment violation, you don't have a right to take my phone. And the judge also demands that defense counsel turn your phone off. And she said, I don't want to be part of the truth check. We already are. This is the starting point to this trial. And the state says, well, the court has a right to, keep the court secure. Absolutely, you do. Absolutely. Have a right to determine who's filming. Absolutely. But what was interesting in the state's argument is they forgot to mention that the court never looked at the prosecutor and said, hey, turn your phone off. Make sure your phone's off. It's all directed at him and his attorney. You can't take cell phones. You can't do that. It's structural error to do that. And it also kind of shows that the court had an animus towards Mr. Castro, then judge. He makes a statement to the marshal. It's unacceptable. It's unacceptable. It's clearly unacceptable. The judge was agitated by it. Understandably so. As I look at that, I'm like, I come in these courts all the time. You don't get to call a marshal what he gave. So, I understand. That's a different matter. He's not on trial for calling a marshal a name, which he shouldn't have called. Maybe you could hold contempt proceedings for that. There are remedies that a court like yourself can do if somebody's being disruptive. Just because somebody's disruptive in a murder calls your court staff a name, it's inappropriate. I would realize with a client of lawyers it's not looking good. But that doesn't mean you're going to find or suggest that the person committed murder simply because he's acting or she's acting in a fashion in a courtroom that shouldn't have happened. But it was clear then that the trial was going the wrong way. So when we look at the facts of the case, that the police officer testifies that this auditor approaches, says that he's a member of the press, identifies him immediately as a member of the press. I have video here. I also have exhibits. And that he wouldn't back up. Now at trial, that was commented on by the officer a couple of times. He wouldn't back up. He wouldn't back up. The prosecutor argued it. Then they started on the 21-foot rule. It's an imaginary rule. We all know there's no such thing as a 21-foot rule. It doesn't exist. But nobody was stopping that. Not defense counsel was saying, where is this coming from? What rule are you coming to with this? And the prosecutors argued, well, he's violating 21-foot rule. There's no such thing as a 21-foot rule. And the state, to their credit, has abandoned and completely retreated from the 21-foot rule on this appeal. They don't argue that. Yes. Yes. But I understand what it is, Judge, because I've used it myself in murder cases, and that is what they're argued that my clients are enduring is that if a man, an assailant, comes at an officer or a citizen, within 21 feet you won't be able to draw your weapon. That's what they're taught. So it's something that we use in a self-defense case. Oh, look, the guy was, coming, and so my guy had no choice but to shoot. I understand that's what police officers are taught. But that's got no bearing on this. There is no 21-foot rule. And in fact, we just go to Click. Click is a First Circuit case. Both the state and myself rely upon it. And in Click, I thought the language was so important to this case, because in Click, they begin speaking about that officers, in that case, first is filming on Boston Common, filming from 10 feet away, 10 feet away. That's very relevant, because the police officer in that case said, Mr. Castro was 10 feet away. And so the First Circuit said, that is 10 feet away, and then the First Circuit starts saying, police officers need to deal with provocative and challenging speech. They further identify that when a police officer comes in contact with somebody who's being rude or obnoxious, that they feel like they shouldn't be filmed. that they shouldn't have to insure that. And the First Circuit then goes on to talk about that officers sometimes retaliate because they don't like it. They don't like it. And they said that's what happened in Clinton. The officers didn't like it. You don't film us. You have no right to film us. Okay? And so when I look at the situation, I'm like, officers, we have a right to film officers. In fact, we have an actual statute on it. NRS 171.1233. This is cited in page 2 of my reply brief in footnote 1. Subsection 2, subsection A states, a peace officer shall not act to interfere with a person's reporting of law enforcement activity, including, without limitation, by A, intentionally preventing or attempting to prevent the person from recording of law enforcement activity. You have a right to do it. We know it by statute, we know it by federal law. So, what does Mr. Castro do? When the officer tells him, back up, I can prove he does. I've attached the exhibits. I don't, if the state wants me to, I'll put it up and I'll show it, but we can see from Exhibit A that where Mr. DeCastro is standing, he's standing in a particular parking space. You can see in Exhibit B, he has now moved back into the back parking space. I don't, when I say back parking space, I know that may be not a good record, but he's moving away.
Right, it looks like it's in a parking lot.
Yes, it's a parking lot. He's moving from one parking space away. You can see it's away from the officer. So the state, to continuously argue he would not back up. Why are they doing that? Because they want to say he won't follow the commands. And the accurate answer was, and I think the court would say, if you were asked to look at this case and say, what did Mr. DeCastro do when he was told to back up? He backed up a short distance. That would be fair. Maybe the court would not like that language, say maybe it's a few feet. But he did back up. What is not fair is he would not back up. He would not comply. He did not back up. And then the officer was asked, did you ask him, tell him how far? No, because he was disruptive. So I couldn't tell him how far. The 21-foot rule. There is no 21-foot rule. Click said 10 feet was fine. And in Click, what's more interesting about it is the officers, what Click is deciding is not like this court deciding whether there's a criminal activity. Click is suing the officers. And the officers are over in federal court saying, oh no, give us qualified immunity. And the federal court saying, no, not for this, you're not getting, for arresting somebody who's filming, you're going to get sued. You're not getting qualified immunity. You're going to have to fight this and go to a jury. I think that's very relevant because that's what's going to happen with this officer. Undoubtedly, you know he's going to sue, and I think he's already started that process. I'm not a civil lawyer, so don't do that. But I know that that is what's taking place. So what is hindering this man from obstructing him from for a suspended sentence? And Judge Zimmerman decided to give him the maximum. He's been in there 4.5 months for this. And I kind of wonder.
So that characterization is, it's not a maximum. It's 3 months on each count consecutively.
Oh, you're right. Okay, you're right. I stand corrected. For whatever reason, I guess misdemeanor 6 months. Yeah, so she gets it. But the state didn't ask for that. They asked for concurrent 90 days suspended. It goes to show what really happened. There were so many different errors. And I can tell the court has a good handle of this. Judge, there is no resisting. It was an unconstitutional arrest. The man should receive the benefit. I mean, we have a beyond reasonable doubt standard. We can look at Wilson. I now hear the state really struggling. They almost sound like me in a bad murder case where they're saying, well, what is physical conduct or contact, because that's what Wilson said. And they're struggling with it because they don't even, because there is no physical contact. Backing up and filming and then pulling out a second camera, it's not physical conduct. There's nothing physical. He doesn't do anything physical. The officer just lost control, and he was irritated. Maybe we understand. It's not.
Yeah, you can understand.
Yeah.
I can understand.
Okay,
And it kind of comes out of nowhere.
It's out of nowhere. It's who wants to be called names? But that's what the courts are all saying. We've got to ensure this. Our citizens have a right to do this, and it also keeps our police. These auditors do help in some way because sometimes they prove police are doing. If it was an auditor on what he did, and that one was like, oh, he was saying these things to me. No, he wasn't. If I'm not a witness to it, no, he isn't. And the video shows that if somebody was filming it, he wasn't doing anything wrong. So some false allegation by some crazy lady, okay, it helps them sometimes. And also, sometimes it catches bad police officers. here, what we have is a situation where you have a right to do it. And so for those reasons, I ask that you grant the appeal and reverse this man's conviction.
Anything else from the state?
I would only briefly say that in the Floyd case, no one was arrested. That's what the distinction is there. So people were allowed to film the encounter, and obviously other things happened from that case. But the issue is not that they were filming, that no one was arrested there. And the case law makes it clear, and listen to the other ones, if there's a probability of substantial harm or death, then individuals can actually interfere and it wouldn't be obstructed. So the case law, I just want to point out that distinction, but otherwise I have nothing else.
Okay, so at this time, the court's going to grant the appeal and reverse the convictions based on its First Amendment protected conduct. And Mr. Long, you can prepare the court.
Yes, ma'am. Thank you very much, gentlemen.
He needs to be released from custody, so.
He'll be released.
Thank you.
Thank you.
Ready, sir? No. That is an arrestable offense, I'm sorry.